The Victorian morality, where a woman gave irrevocable consent in marriage, continues to be preserved in the statute books of India. A husband cannot be prosecuted for the rape of his own wife. Section 375 of the Indian Penal Code lays down the exception, and I'm quoting, sexual intercourse by a man with his own wife, unquote, is not rape. The exception in law has its roots in the concept of implied consent by a woman given in the marriage, and a grim reminder of the times of England when women were considered as mere chattels or property and had no inheritance rights. Hello and welcome to this edition of Let's Talk Law. I'm Anusha Soni. Today we talk about the issue of marital rape and whether it should be criminalized in India. Even today, India is one of the few democratic nations that does not recognize the offence of marital rape. The Supreme Court of India shall have the final word on the matter, whether rape within marriages should be criminalized and recognized. After a split verdict from the Delhi High Court, multiple petitions have lined up at the Apex Court seeking criminalization of marital rapes. The hopes are pinned at the Supreme Court of India. The union government, during the hearing at the Delhi High Court earlier, had opposed the criminalization of marital rape, apprehending it will lead to breakdown of families and widespread misuse, like 498A. The position is not new. Even in the earlier UPA-2 government, the government did not at that time implement the Justice Verma Committee recommendations that had advised the criminalization of marital rape. You'd remember, the commission was formed in the aftermath of the Nirbhaya case. We missed that opportunity. Talking about history and how law has evolved, over a century has passed, but remnants of the Victorian morality continue to survive in the Indian statute books. The Hale's Law of England, laid down by Sir Matthew Hale, the Chief Justice of England between 1671 and 1676, said that a man cannot be booked for raping his wife. This rule made it legally impossible for a husband to be prosecuted for the rape of his wife, and that's where the origin of this proposition lies. Now, in England, after fierce opposition, the rule was struck down in the country about 3 decades ago in the historic case of R versus R in 1991, after surviving for more than 300 years. But the colonial shadows of it continue to survive in India. No one denies the existence of rape within marriages. In fact, there is abundant statistics to prove the presence of physical, emotional, sexual assault within marriages. Despite the acknowledgement of the stinging reality, there has been a fierce opposition from certain quarters and reluctance from the government to do away with the exception. This exception that grants immunity to a husband for being prosecuted for the rape of their wife. The opposition to criminalization of marital rape can be broadly divided into 2 parts. First is more in principle. It's argued that criminalization is against the very idea of marriage, where the consent to intercourse is implied and perpetual, a component that cannot be taken away from the institution. The puritanical perspective shall also have us believe that such interference in bedrooms shall lead to breakdown of the families. These ideological battles have been fought by the feminists in countries like US, UK and many other parts of the world. Well, the answer to such apprehension is plain and simple. The institution of family and marriage cannot rest on the foundation of abuse and violence. It must be dignity and respect. There's nothing personal, as they say, about personal laws and personal space. The second limb of the opposition is rather a serious one. The provision of marital rape arguably can be used as a tool for harassment, like the anti-dowry provision of the 498A has been rampantly misused by many. Upon a complaint of rape, the arrest of the accused is almost certain, and the fear of revenge litigation in marriages gone sour cannot be brushed away. That's what most experts argue, or the people who say criminalization should not be done argue. To take care of such concerns, there needs to be a smart, intelligent legislative policy framework in place. Only a well-drafted, well-thought-out special legislation can take care of the procedural concern. Now, while the absence of any witness is not impossible in ordinary cases of rape, but in the cases of marital rape, it's almost certain that it's unlikely to have any kind of witnesses to the crime. Can sheer procedural or evidentiary concern impede law from recognizing such a heinous offence? Well, sure, there are challenges, and equal regard should be paid to the right of the accused or men. But the procedural concerns cannot overtake the principled approach that the law must take. The slow and tardy pace of litigation in India, corruption, inefficiency within the police machinery, it has dampened the spirit of many other laws on the statute books. False cases, false allegations can be made against anyone for any offence. Procedural concerns should not be used as a garb to assert the misogynist notion that women lie or are unreliable. The real concern of safeguarding the rights of the accused should be met with legislative expertise. While the courts can tread upon the path of striking down the exception under the Indian Penal Code, only a smart legislative approach can address the evidentiary and procedural concerns. Marital rape should be criminalized in India, but with caution. Courts and Parliament must ensure that it's not used as a tool for some kind of harassment against men. But reform should not be withheld hostage to fear-mongering, which is premised on phobia of false cases. It should not be the reason for law to recognize and punish a heinous offense, a heinous crime like marital rape that continues to happen in India and many other countries across the world. We hope that the Supreme Court takes up the matter very soon. Thanks for watching.